Looks good, or no? Yeah,
I'm not seeing anything on the YouTube page. Oh, wait, there we are.
Live, though.
I see it now.
Yeah, great. So if you want to stop.
Hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, Council, and welcome to this morning's session of the Appeals Court. My name is Jeffrey Kinder, and I'm joined this morning by Justice Suk-Young Shin and Justice Catherine Hand. We will be your panel for this morning's case. As you know, we're conducting this via Zoom. Bear in mind that it's possible that from time to time we may have a technical glitch. Should that happen, just bear with us. We'll suspend momentarily, put you in the waiting room, solve the problem, and come back as soon as we can. So please be patient with us. Also, bear in mind that we are streaming live, so that even though you may be muted while your adversary is arguing, we can still see you. So please keep that in mind. The rules apply just as if we were in the courtroom. Each side will have 15 minutes and there is no rebuttal. We have carefully reviewed your briefs and the relevant portions of the record, so your time is best served if you get right to the heart of your argument. So with that, let me turn to the first case, which is 19P 1594, Commonwealth versus Cortez. Ms. Cusack, on behalf of the defendant.
Thank you, members of the panel. Good morning, and may it please the court. Kelly Cusack on behalf of Mr. Cortez. I'd like to start with my strongest argument that may provide the best relief for Mr. Cortez, is that regarding the sufficiency of the evidence introduced by the Commonwealth at trial related to whether the defendant possessed or intended to distribute the drugs and contraband that were recovered during the execution of a search warrant on December 12th of 2013. Mr. Cortez was convicted of 3 indictments: possession with intent, heroin, morphine, and Suboxone. This issue was preserved by counsel, who moved for a required finding of not guilty during trial, and then subsequently after the jury's verdict of guilty, pursuant to a motion under Rule 25b2. In viewing the evidence in the light most favorable to the Commonwealth, any rational trier of fact here could not have found the essential elements beyond a reasonable doubt. First, with possession. On December 12th of 2013, members of the Quincy Police Department make entry into the apartment 40 Nelson Street, top floor, number 10. They do so by way of a mechanical device because the door is fortified and barricaded. Once inside, police officers describe the layout of the apartment as being 2 floors. The first floor with a living area and kitchen, and then the second floor, 2 bedrooms and a bathroom. I think it's important for this court to view, to place importance upon where the individuals are located, but more importantly, where the drugs and the contraband are located in making this evaluation about whether there was sufficient evidence presented that Mr. Cortez possessed and or intended to distribute the items. Upon entry, in the kitchen area. Throughout the testimony of Officer Duran, who searched the bedroom where a bedroom upstairs, he indicated, and it was testified to, that that bedroom belonged to Mr. Bonet and Miss Monaco. I would suggest that given this evidence, there was exclusive occupancy for that particular bedroom. It's stated on the record throughout testimony on pages 32, 34, and 35 of September 13th from the trial testimony of Officer Duran, who had searched that particular bedroom. Within that bedroom, there were 12 bags of heroin found and 17 blue pills of morphine, which stood for the 2 convictions of possession with intent, morphine, and heroin. Additionally, within that room were a box of baggies and baggies with the corners cut off, a paper with numbers and names on it. I would suggest to the court that what the Commonwealth has to prove for possession in this case, particularly where no items were found on Mr. Cortez, is constructive possession, whether he had the requisite knowledge coupled with the intention and ability to exercise dominion and control over those items.
Ms. Cusack, the list of items that you just referred to that were found in that bedroom were not concealed in any way, were they?
It's unclear. It wasn't developed in the record where exactly those items were found. The only thing that was clear was 17 blue pills were found on a bookcase in the bedroom. I don't know, based on the record, whether that was or was in fact concealed. But what I would suggest is this is a bedroom shared by two individuals who were not Mr. Cortez. There's no reason to believe that Mr. Cortez would have any knowledge of the items in the bedroom, no matter where they're located, concealed or otherwise. With respect to the items located in the bedroom where Mr. Cortez was, were 6 Suboxone sublingual strips that dissolve under the tongue, 8 tablets, along with additional smaller piece of a Suboxone, a digital scale in the box, some baggies, telephones, and another sheet with names on it and numbers, along with some money. In this case, in the bedroom where Mr. Cortez is located, going to your point, Justice Kinder, none of those items were located out in plain view. The Suboxone strips and 8 tablets with the additional piece were found tucked into a drawer. The digital scale, it was in a box on a dresser. In particular, what they referred to as a cuff sheet was located in a closet. So none of the items or contraband were out in the open. They were all tucked away. I think this court—
Excuse me, am I correct that the cuff sheet had a nickname by which Mr. Cortez was known on it?
That was raised in the Commonwealth's brief. However, that was not introduced at evidence during the trial. It was certainly raised during the motion to suppress, and it was included in the search warrant affidavit, but none of the officers or anyone that testified at trial indicated that Mr. Cortez was in fact Red or that Mr. Bonet was in fact Dre. It was only physical descriptions given of Mr. Bonet and Ms. Monaco upon cross-examination because they were the targets of the search warrant and Mr. Cortez was not. So I would suggest that that was not in evidence and should not be considered by this court, that nickname matched with Mr. Cortez, because that wasn't the evidence that was introduced at trial.
So I just want to make sure I understand. The cuff sheet itself is in evidence, correct?
The nickname, correct, but the nickname
Right.
Red
You're
is
saying that
not
there's
in evidence.
you're saying there's no evidence in the trial record that Dre was the defendant's nickname.
Red was the defendant's
Red,
nickname,
okay.
and that Dre was the Mr. Bonet's nickname. That was discussed during the motion to suppress, but was not introduced as evidence at trial. What I would suggest to the court here, again, there's no forensic evidence connecting Mr. Bonet, or I'm sorry, Mr. Cortez to any of the items, such as fingerprints or DNA. Mere presence, even with the knowledge, is not enough to prove possession. I know and looking at the particular factors to determine possession, there are no personal effects of Mr. Cortez, including any mail addressed to him or an identification, such as a driver's license or passport with his information on it, or that address of 40 Nelson Street. There's no consciousness of guilt. While he's not particularly described as to what he's doing in the bedroom or what he's wearing, it's clear he's not fleeing. He's not making any attempts to destroy the evidence. Police observations throughout surveillance show Mr. Cortez bringing groceries up to the apartment. I know the Commonwealth relies heavily upon the barricaded door as proof that there is a factor to be determined for possession. And I would suggest that the court look at Commonwealth versus Brown, which is cited in my memo and brief and was relied upon by trial counsel, that presence and awareness alone is not enough for an inference that there is an ability to exercise dominion and control. The barricaded door cases relied upon by the Commonwealth all are not only barricaded, but sparsely furnished. That these particular houses are what would be considered a hot or a hustle house, meaning that there's no other traditional reason to live or be inhabited, or that no one is inhabiting that particular residence. And I would suggest in this case, while not fully developed in the record, there's our photographs with the exhibits of where they're located. There's descriptions of bureaus and dressers and nightstands and beds, clothing in the closet. It's clear that this isn't just a hot or hustle house or a headquarters of a drug operation. I would suggest, with respect to intent to distribute, there was insufficient evidence presented by the Commonwealth that even if the court finds possession, which I'm not conceding, there are no factors here present for intent to distribute. There's no large quantities of the items that are located, despite there being 12 bags of heroin, the weight of which is under 4 grams. There's only 12 bags, there's only 6 Suboxone strips, which are sublingual and unable to be cut down or further distributed in a way. And the pills themselves there's only 8 tablets. While there is some amount of money recovered, $1,000 is recovered from Mr. Bonet, and there's $850 in the room where Mr. Cortez is, but it's unclear where the money is recovered. While there was no particular ingestion paraphernalia present, the items that are recovered, sublingual, Suboxone tablets, strips, and tablets are certainly orally can be ingested. And it was testified to with the drug expert that heroin can also be sniffed. So it's not the type of drugs that you're expecting to have any of those particular paraphernalia. These items can be taken without those other things. So I would suggest to the court that there was insufficient evidence presented both for possession and for intent to distribute. If there's no other questions on that particular argument, I'll move quickly to try and address the motion to suppress and the motion for the informant.
You may proceed.
With respect to the defendant's motion to suppress, I would ask this court to find that the motion to suppress the search warrant that was executed at 40 Nelson Street, there was no probable cause to issue that search warrant based on the unreliable informants without any further police corroboration, did not establish the requisite probable cause to issue the search warrant, and anything that was recovered as a result should have been suppressed. So the court should grant a new trial and allow that order to enter.
If we agree with you that there were any weaknesses in the information regarding the informants, aren't those overcome by the substantial evidence of police surveillance in this case?
No, Your Honor. What I would suggest is there are weaknesses within the informants, and while there is some surveillance that's done over 6 days, there is not a lot of specificity on those particular 6 days. They allege that they see certain transactions, but there's no items that are seen or recovered. The police don't do any stops of the buyers to determine how exactly the operation is working, what the drugs are that are being distributed, if they are any, out of the house. And in fact, when they do the controlled buy with the last informant, CI3, who didn't have any basis of knowledge or veracity, the item that was recovered was cocaine, which didn't even match what was actually recovered through the execution of the search warrant. So I would suggest that the hand-to-hand transactions they alleged they saw were unverified, and they didn't have any specific information as to what was happening other than the observations that they made. With respect to the probable cause for the issuance of a no-knock warrant, while it's codified in common law, here the only reason that the officers requested a no-knock warrant was based on the evidence that it was drugs and in an old conviction for Mr. Cortez. The law is clear that there needs to be unique circumstances to permit a no-knock warrant, and it can't be based just on the alleged destructibility of the evidence. The bare assertion that someone is armed and dangerous or that guns go along with drugs is simply not enough to get a no-knock warrant. The police—
Can I stop you on that point?
Sure.
The claim that a particular suspect is armed and dangerous or might be considered armed and dangerous is not enough for a no-knock warrant?
Not standing alone. I think there needs to be more than a blanket assertion that someone is armed and dangerous. Here, the police attempt to justify that by admitting that they know Mr. Cortez has a 1997 conviction for a firearm where he was sentenced to 71 months, which would be the equivalent of about 5 years, and that he currently has a warrant. There's no indication that this warrant, other than it's a probation warrant, is connected to that underlying conviction that is almost 20 years old at the time that they are executing this particular search warrant. So I don't think that they can use those facts, other than the drug operation and the fact that he had a prior conviction in 1997, to justify the means of obtaining a no-knock warrant.
But we don't look at those factors in isolation, and neither is the clerk magistrate or the issuing authority looking at those. They're looking at the warrant, the past history, the armed and dangerous information, the layout of the apartment as it's set forth, the ease or lack of ease in getting in and out of the facility in a common sense way. Would you agree on that?
I would agree on that. And I think that a part of the issue with the informant's information and the police observations is that they don't have any of that information on whether or not the interior of the apartment, whether it's close and confined. They certainly didn't have information that the doors were barricaded based on their the buy that was created by CI3, or any other further information other than that officers had been in that particular apartment building before, but not in that particular apartment. I see that my time is up. If there are no further questions.
I'm sorry for interrupting, but let me stop you for a minute and see if there are any further questions. Seeing none, thank you, Ms. Cusack, for your argument.
Thank you.
Ms. Glennon.
Good morning. May it please the court, Stephanie Martin Glennon on behalf of the Commonwealth. First, the Commonwealth's position is that the four corners of the search warrant application here provided ample cause to believe instrumentalities of a drug enterprise would be found in apartment 10. And regardless of consideration of the confidential informant information here, the police observations here alone would have sufficed to support probable cause for the warrant. Here, experienced narcotics officers and investigators had spent approximately the preceding week watching two targets come out of the apartment to make what these experienced officers observed to be apparent quick, within a matter of seconds, hand-to-hand apparent street-level drug sales to a series of buyers, almost all of them known personally to the investigators. And within 72 hours previous to the search warrant application and its execution on December 12th of 2013, had supervised, overseen a controlled buy inside the apartment between an informant and Bonet. I'd like to just briefly address the defendant's argument that the no-knock provision within that same search warrant application was not adequately supported by probable cause. As my sister noted, the requirement of a knock is not a constitutional requirement. It is something that is dispensed with in any one of three different circumstances, all of which were present here. One is a showing of a threat to officer safety in executing a warrant. The second is a showing of a likelihood that a substantial amount of evidence will be destroyed. And third is something that arises under Jimenez and its progeny, with where circumstances which the officers encounter in executing the warrant would render a knock and announcement a meaningless gesture, or a meaningless or useless gesture. As to the first, as to the threat of officer safety, the defendant has not disputed anything within the search warrant, has not challenged the basis or alleged that there was any kind of bad faith or fault in its execution. So here, as to threats to officer safety, there was unquestionably, and I think this is completely covered by Commonwealth versus Tatum, is exceedingly on point here and controlling. And I have not seen any authority that differed with that, which is where someone was reasonably believed to be inside a target dwelling, in that instance, a third-party dwelling, and where the defendant in the case in Tatum was reasonably thought to be inside by the police who were charged with executing a warrant and was subject to an outstanding warrant. That alone would have been sufficient to justify the no-knock provision. Here, the defendant was known to be armed and dangerous and the subject of an outstanding federal warrant on a firearms offense. There was a reference in the search warrant application to an additional associate of the residents of the apartment who had been observed by the police during their investigation, during their 6 days of surveillance, and who himself was known to have sometimes had firearms, and that was enough under Valerio to determine there was a heightened risk to police officers. There were other hazards that were set forth in the search warrant application, which was extensive, and those included very specific factors, not only about the layout of the apartment, but the layout of the observed premises inside and outside in the entire apartment building complex. Just as one example, there were photographs appended to this submission, and there was discussion in Sergeant Duran's affidavit of factors such as the exposure that officers would have in where they would necessarily need to enter, and the exposure in turn that other civilians, other people on the premises would have were they to approach that way, which was really their only entry into the building itself. And just for example, there's a narrow wooden stairwell they would have had to enter, which looking at those photographs, reading the discussion of that, is in very poor condition. And there's a photograph of that, I think, at pages 270 to 271 of the appendix. There are, even that aside, there's an additional, had there been no knock provision, I would suggest that the circumstances, the undisputed circumstances which confronted the officers at the threshold would have allowed them to enter without a knock, because it would have become a meaningless gesture. Again, it's uncontested that what police encountered at the threshold was a door they could not open, was a place they could not enter physically to execute the search warrant. And at that threshold, the officer Duran said he heard movement. The police there to execute the search warrant heard movement inside, which is necessarily means that the people inside knew they were there. And it not only indicated that a knock would have been a useless gesture, but it also dramatically escalated all the threats present to them, present to civilians, and also markedly increased the threat that a substantial amount of evidence was going to be destroyed, as in fact the circumstances suggest occurred, because what confronted them on entry was an interior barricade so formidable that they had to call, a battering ram wasn't enough. They had to call upon a SWAT team to physically, mechanically enlarge and reconfigure the door frame in order to get in. And in the time it took them to enter, when from the beginning at the threshold, they had heard movement inside, people moving around. By the time they entered, then not only could people inside have armed themselves, but they could, and I would suggest the evidence shows that they did, they were able to destroy a significant amount of evidence. By the time police then were able to make entry, they found all three inhabitants, all people present inside the apartment, the defendant, Monaco, and Bonet, were in different parts, different rooms of the apartment. They found Bonet in the bathroom with $1,000 in cash and an empty glassine bag in the sink. So there was certainly an inference available to the jurors as well, going to the third issue here, that Bonet had been able at least to destroy the cocaine that may have been on hand in this enterprise. As to the defendant's next argument concerning his claim that he was entitled to the identity, the name and identity of a confidential informant.
Interrupt you. I did have some questions about the last argument, sufficiency, and I want to make sure you don't run out of time. Is your sister correct that there's no evidence in this record about the defendant going by the name Red?
Well, Your Honor, first of all, that the jurors could see the defendant. He's conspicuously redheaded. They would have been able to see that. Andreas, they had the name Andreas Bonet, and Dre, I think they could also have certainly referred to him. And there was not one but two cuff sheets. One of them was found with the defendant, and in concert with it contains entries which also the jury heard expert evidence on all of this, and as to how the amounts of the entries would have reflected.
Is there any evidence he was known by the name Red, or any evidence that he had red hair, anything to connect him to the cuff sheet?
He was found with one of the cuff sheets.
I thought it was in the closet.
And also with folds of cash in the amounts, and with $850 in non-distinctive folds of cash,
could you
just as the expert.
Counsel, I'm just trying to ask you whether you can point us to anything in the record that shows, the trial record that shows he went by the name Red.
I'm suggesting that is an inference, a rational inference that the jury could have drawn from seeing him and from the circumstances, which included that the three of them were there, the people inside the apartment and the entire enterprise, that suggested that the defendant's role in this.
Is there any evidence in the record about his appearance and that he had red hair?
The jury could see him.
But Ms. Glennon, the question is, what in the record tells us he had red hair?
Your Honor, I think there's the inference that the people inside that apartment who had those cuff sheets.
That's a different issue. Is there anything in the record that tells us he had red hair?
There is no direct testimony that he had red hair, no.
Thank you.
Your Honor, I'm not sure if I finished answering your question.
So I had another question. In the bedroom in which the defendant was found, my understanding is the only thing that was in plain view was the scale and the cell phones. Do you agree with that?
I don't think so, Your Honor. Okay, there's the precise digital scale in the bedroom. There was the defendant's own cell phone, and there was a separate clear bag with 5 additional burner cell phones. There's a photograph in evidence of an open drawer which had many boxes of baggies. There's also a photograph in evidence of an open trash can which contained not trash but rolls of pre-adapted already corner bags. And I think this could have been considered by the jury also in connection with the evidence that the 3 people inside the apartment had time to begin to conceal and dispose of evidence, certainly to conceal evidence, by the time that the search warrant execution team was able to enter. And I think that it needs to be, it could have been rationally considered that way as well. So whether or not, say, the lid was open as it is in the photograph, showing these already adapted corner bags, which the expert testified would have been how drugs would be packaged for street level sales. Whether or not that was open, jurors could also have considered that some efforts could have been made by whoever was in that room, in this case, the defendant, to begin to conceal evidence. That there was a dresser drawer pulled out which only contains baggies, no personal effects. I think rational jurors, the rational triers of fact, considered as more evidence that the defendant was indeed the person within this enterprise who was not simply staying there as a guest, but was using these implements, the adapting the bags, the packaging, was weighing the drugs, and that was his role in the enterprise. I'm not sure if you want me to address the confidential informant issue or not. I can't actually see the clock. I'm sorry.
You have 1 minute and 20 seconds, and the time is yours to use however you'd like.
Okay, thank you, Your Honor. As to the identity of the confidential informant, I would say there were two judges involved, and in both instances, one was the trial judge who was best situated to see that this informant would not have been material to any issue in the defendant's trial, and that both judges were warranted in finding the defendant had failed to meet his burden to override the privilege against disclosure of the identity of a confidential informant who had been referred to in the search warrant as purchasing drugs from Bonnet, but the defendant agrees had no dealings with him. The defendant hasn't suggested any element of the possessory offenses against the defendant on December 12th, 2013, to which this informant who had no connection with him could have had any material information to offer, and would just say that to the extent the defendant claims that his own absence from a sale made by Bonnet to a buyer was even arguably relevant to any issue at his trial, in his case, the defendant not only could have called Bonnet himself, the other person presumably
Ms. Glennon, excuse the interruption. I see that your time is up. Let me see if there are any follow-up questions.
Okay, thank you, Your Honor.
Seeing none, thank you both very much for your argument. The case is submitted. We'll take it under advisement.
Thank you, everyone.
Thank you. Morning, Council. My name is Jeffrey Kinder. Welcome to today's session of the Appeals Court. I am joined today by Justice Suk-Young Shin and Justice Catherine Hand. We will be your panel for today's case. Although we are streaming this case virtually and conducting the hearing on Zoom, the same rules apply as if we were in the courtroom. So as you know, you both have 15 minutes to argue your case. We will interject questions from time to time, and there is no rebuttal. We've carefully read your briefs and the relevant portions of the transcript and record. So I would suggest your time is best served if you get to the heart of your argument. So with that, let me call the case. It is Commonwealth versus Barbosa, 19P 0435. Mr. Driscoll represents Mr. Barbosa. You may proceed.
Thank you, and may it please the court. Mr. Barbosa was the victim of two structural errors in this case. The first happened before trial, which was a Goodwin error, where he was denied the ability to plead guilty due to prosecutorial vindictiveness. The second structural error was his denial to self-representation at his bifurcated habitual criminal trial. That his denial was based on judicial error. The judge believed that a defendant could not change counsel in the middle of trial, as he put it. But our statutory law says that he can. So it was clear error to deny Mr. Barbosa that right. He did not go into the Ferretta analysis to ensure that Mr. Barbosa's decision to proceed pro se was voluntary and intelligent. However, the record displays that it was.
Let me ask you a question about that, Mr. Driscoll. As I understood the transcript, Mr. Barbosa wanted to represent himself because he wanted to present an argument that the habitual criminal statute was void as to him. And the judge engaged in a fairly lengthy discussion with Mr. Barbosa and with his counsel at the time regarding the merits of that argument and whether or not that was an appropriate argument to make. Do I have that portion of the transcript correct?
That was one of his arguments. However, a defendant has the ability to defend himself under the Constitution, and he has the ability to fall on his own sword, if that may be.
After that fairly lengthy discussion, I didn't see anywhere in the transcript thereafter where he again asserted his right to proceed pro se.
It was preserved because he had already been denied. The judge had told Mr. Barbosa, you're being represented by counsel, basically, whether you like it or not. And he did not. And the Constitution says the judge was wrong. And the judge's belief is wrong based on Calusa, where General Law, Chapter 278A, Section 11A, states that the second stage of a bifurcated trial is just like the first. He is entitled to counsel of his election. They were about to choose.
If the judge drew the inference or made a conclusion that the purpose Mr. Barbosa wanted to proceed to trial was to make that legal or constitutional argument about the applicability of the statute, couldn't he have concluded that that decision by Mr. Barbosa was not a knowing and intelligent decision?
No, because the question is not to analyze Mr. Barbosa's case strategy. It is to decide whether or not he voluntarily accepts the reality that a pro se litigant is severely disadvantaged. And if he understands that, then under Miranda this year, Commonwealth v. Miranda, which quotes Ferretta and McCoy v. Louisiana, the Constitution provides that he will make all decisions in his case. Now, during trial, if the judge wishes to cut him off with certain arguments, that's another issue. But Mr. Barbosa had the constitutional right to make whatever ill-advised or otherwise decisions about his trial and to question all witnesses.
Did the judge in this case have the ability to circumscribe Mr. Barbosa's ability to claim a pro se representation status given the timing of that request? Meaning,
no, actually, the day
trial?
After his rape conviction, the parties returned for the bifurcated second half of the trial. And Mr. Barbosa asserted in October that he wanted to represent himself because his trial attorney said he was totally unprepared. They returned in December, 2 months later. Counsel and the client could not agree on a trial strategy. Counsel was still not prepared to move forward. He asked for another continuance. And Mr. Barbosa said, I want to represent myself. I am not happy with my counsel or how he wishes to proceed with this case. And basically, he wanted to fall on his own sword. And so be it.
This was a fairly unusual procedural posture in that, as you know, they were at the midpoint of a bifurcated trial, and the sentencing enhancement portion of the case would be very limited in nature, which was the subject of the judge's discussion with Mr. Barbosa. Isn't that procedural posture something that we have to take into consideration with respect to the timing of the request?
No, because this is a trial, and the trial subject matter does not limit Mr. Barbosa's constitutional right to decide his own representation. That's just like Confrey, where the defendant was forced to allow standby counsel to cross-examine the victim. And he was denied the right, even though he was going pro se, to cross-examine that witness. That was error. That was error. The core right of Ferretta was the actual control over his case. That's what
one of the things that I recall about Confray was that the defendant continued to pose objections during the course of the trial, including during cross-examination, regarding the awkward nature of that cross-examination. I didn't see or hear any objection by the defendant in this case after that initial discussion with the judge at the beginning of the penalty phase.
This is the second day that Mr. Barbosa was present for trial. Both times the judge said, I'm going to deny you. You can take it up on appeal. Your issue is preserved, but let's move on. I don't want to hear another thing. So it was preserved at that point. Mr. Barbosa does not have to keep objecting in the middle of trial, standing up when his representation at that point that was forced upon him is making his case. Mr. Barbosa is not required to stand up in that case in front of the jury and say, Your Honor, I want to represent myself.
Well, one of the findings that judges are called upon to make is whether or not the defendant's assertion of his right to proceed pro se is unequivocal.
Yes.
And well, I guess I asked you this before, but I saw on that second day in December, before the penalty phase of trial, I saw only that initial objection and request to proceed pro se. Is that correct?
Yes, it was at the start of trial. And once the judge told him, I've made my decision, sit down, that was it. He does not have to continue to object throughout trial to have that preserved because the judge told him it's preserved. So due to that structural error, Mr. Barbosa is entitled to a new habitual criminal trial, at which time he can decide how to proceed. And if the judge during the course of trial wishes to rein him in, that is the judge's function. But Mr. Barbosa is entitled to decide his own defense and his own fate because he is the one that will be serving the sentence.
Can I take you back, unless there's any other question on that point, I'd like to take you back to the vindictive prosecution argument.
Yes.
As I understand it, the initial plea before Judge Cosgrove to the agreed upon 4 to 4 in a day, what was rejected by Judge Cosgrove because the defendant did not admit his guilt during the course of that plea colloquy. Is that correct?
That was the finding by a different judge in April of 2016. Yes.
Well, assuming that to be the case, why wouldn't that reason, that is the defendant's refusal to actually take responsibility and admit guilt, why wouldn't that be a changed circumstance justifying a changed offer?
Because it was more than not admitting guilt. What Mr. Barbosa said in August of 2015 was, I want to challenge the DNA evidence. And he did just that. Within a month, his then standby counsel became his full-time counsel and pursued a motion for DNA on the evidence. Unfortunately, defense counsel let that drop. And by January, Mr. Barbosa sought to have him discharged, a hearing that was not heard until April of 2016. At that time, he had already had it with his defense attorney. His defense attorney appeared at that hearing saying, not even to represent Mr. Barbosa, he says, look, I just want out of this case. I'm reluctant to say anything whatsoever. He was not being represented by counsel even in April 2016 because his counsel walked away from the case. He said, I just want out. I'm not going to say anything.
It's not clear to me why any of that results in prosecutorial vindictiveness.
Well, the prosecutorial vindictiveness came about because Mr. Barbosa was not represented in August of 2015. He engaged his right to counsel, or constitutionally protected right. And in July 2016, the prosecutor is on record of saying the only reason why we made that August offer was because he was pro se. Because he was no longer pro se, they wanted to increase the penalty to 5 to 7 years. That's based on his acquiring counsel, a protected right. That makes it prosecutorial vindictiveness as a presumption.
Could you just point me, I'm sorry to interrupt you, could you just point me to the portion of the transcript where that takes place? Do you have the page number?
Yes, that was July 2016 on page 9. At that point, the Commonwealth, the defendant was pro se, and he would be cross-examining his own victim. That's why we agreed to a 4 to 4 a day. So
you've sort of focused on that, and I understand why. But I guess I go back to my earlier question. That isn't necessarily the only reason for an adjustment in the offer, is it?
Well, the judge in April 2016 went through the realistic likelihood standard of North Carolina v. Pierce, which is held by Goodwin and our own case of Johnson. And in that case, what happens is once there's a presumption that there's a violation, which we have, then the judge asks, okay, what is your rationale for increasing this punishment? And the Commonwealth gave 3 reasons that were all rejected by the judge. The passage of time. In the last 6-8 months, he's accumulated time, so he's going to be eligible for parole if we let him out on 4 to 4 a day. So we want to increase it, so he has to stay in jail longer. The judge says, no, that's not a suitable reason. Number 2, the agreement was rejected. Well, that was found untrue by the judge because Mr. Barbosa wanted to challenge the DNA evidence. He didn't say, I'm going to reject this because I'm innocent. I want to mature my case, and I need counsel to do that, is what ended up happening. Number 3 was finally the Commonwealth came out and said, well, we just don't think that sentence is any longer appropriate due to the nature and circumstances of the case and the probation record of Mr. Barbosa. And the judge said, none of that has changed since 2014. Since you had the indictment, he has not had any new crimes, his probation record hasn't changed, so he found the abandonment of the 4-year sentence very concerning. And that's why I brought up the Bates and Soares language of adequate and genuine. What the judge did was basically that style analysis and found that the Commonwealth's reasoning was not adequate and genuine, but he was stuck. The court needs direction as far as, well, what do I do in this situation? And with a likelihood of vindictiveness is very high, then as long as the prosecutorial discretion is not overburdened, then the judge should have said, impose the 4-year term. Prosecutorial vindictiveness should be found, and this would be the case to instruct the court.
Thank you, Mr. Driscoll. If there are no further follow-up questions, we'll move on to Mr. McGee. Seeing none, Mr. McGee, the floor is yours.
Good morning, and may it please the court, Michael McGee for the Commonwealth. There was no prosecutorial vindictiveness here. This was a proper exercise of prosecutorial discretion. 8 months after a plea proceeding had been terminated. This was also an individual who had a lengthy border probation history and 2 prior incidents, including a prior rape. This was a brutal rape. And not only did he not take responsibility in August of 2015 for his actions over a period, as counsel discussed in that July transcript, he also took no responsibility on that April 2016 hearing. He called the rape.
Excuse me, Mr. McGee, what do we do with the response to, I think it was Judge Broussard at the time, that one of the reasons for the change in the offer was the fact that the defendant proceeding pro se would be cross-examining his own victim.
What I would suggest to the court, and which is perfectly appropriate, is early in a case, the defendant had, and I'd speak generally and also specifically to the case, this particular defendant was, I believe at the time, had standby counsel. I think it is perfectly appropriate for the court, for a prosecutor, to consider what a trial will look like down the road and say, under these circumstances, even though this individual had already served state prison time twice, for 3 to 3 in a day, for a rape, once for a rape and once for assault and battery of a correction officer, given that he is likely here, even with standby counsel, to be cross-examining the victim of a rape crime, that early in this case, we will offer a 4 to 4 in a day if he's to take responsibility for his actions, and would dismiss the habitual enhancement penalty. And that's perfectly appropriate.
And then how do you explain what it was that changed that caused the offer to go to 5 to 7?
Well, I think what was clear is that, number one, the defendant was very vocal about his not accepting responsibility for the crime. And also, as the case proceeded, it became clear that this was a trial. This was a case, and to that point, this is a situation where the defendant was never going to accept responsibility, and the Commonwealth shouldn't acquiesce to someone that simply is firing his attorneys and demanding to not accept responsibility and wants a certain plea. That's just not appropriate. What was appropriate here was to offer a sentence that is in line with his record and with the facts and circumstances of the case, and his minimization of the crime. And that was why the 5 to 7 was appropriate in April of 2016. I also, does Your Honors have any questions about, before I move on to the other issue?
No, you may proceed.
Thank you. There was a great deal of discussion about the enhancement penalty portion of the trial. And I would suggest to Your Honors that the issue isn't whether he preserved an error. It's whether the defendant was equivocal or unequivocal with his request for counsel to not have counsel. And
can I interrupt and ask you a question on that point?
Of course.
Both in October and 2 months later in December, before Judge Connors, I understood him to say, according to the transcript, I want to proceed pro se. I want to represent myself. What's unequivocal about that?
Well, I think what, and I know Your Honor touched on it, is that the experienced judge here was well within his discretion to inquire as to why what was going on here. And Your Honor was correct, as there was a constitutional issue that not only the defendant was raising then, but had raised in 211-3 motions before that. Additionally, this was not a circumstance where there would be live witnesses. Documentary evidence is an enhancement penalty. And essentially, the defendant wanted to take the stand and explain his factual circumstances of his 2 prior offenses, and he was able to do that. And I think where whether it was voluntary, knowing, intelligent, and whether it was unequivocal goes to that. And it shows that the judge here was trying to make sure that his rights were preserved, but also that that we would proceed in a manner that was appropriate and constitutional, and it was.
So it sounds like you're suggesting to us that we have to decide that the judge implicitly made findings as to knowing, intelligent, and unequivocal?
Well, a defendant is entitled to self-representation if his election to proceed without counsel is unequivocal, voluntary, knowingly made and asserted in a timely manner, and not sought for improper purpose. And that's Conifer. And the improper purpose here was, it was not that it was improper, but that he misunderstood how this would proceed, and he being the defendant. What the judge was well within his discretion to do was to advise him that he can take up the constitutionality of three, as the defendant termed it, a 3 strikes violation. He could take the stand at trial, and he could have a trial by jury, and he could have all of those things. But that this was essentially a documentary evidence portion of the trial for the enhancement penalty, and that he was going to be represented by the attorney that had represented him through this case. And it was appropriate for the judge to allow the continuance after on the first attempt at this trial, so that counsel could be prepared for this. And it was that was essentially the judge was well within his discretion to do all of that.
On that point, the briefs take contrary positions on the standard of review we should employ in this case. Mr. Driscoll suggests we review for structural error, and you suggest it's abuse of discretion. Can you give me some guidance on that?
Yes, and I think some good guidance on that would be Commonwealth versus Miller, 6 Mass Appellate Court, 959. It's a 1978 case that discusses timeliness of a situation like this, and also the unequivocal invocation of the right. This is a situation where it was certainly he certainly was entitled to a second trial, and he absolutely has to. It's a bifurcated trial, but it's an enhancement penalty. And the situation here is that in ordinary circumstances, your trial attorney would carry through. It would likely take place on the day of or the day after the substantive trial, only because the defense attorney was very vigorous in his request for a continuance. Was it allowed? And I would suggest that for the defendant to simply say he doesn't like his attorney and wants a new one right after he was convicted of rape, it was untimely, and as for the reasons I discussed, unequivocal.
Except that he didn't say, I don't like my attorney, I want a different one. He said, I don't like my attorney, I want to represent myself.
Right. And I would suggest that at that point it's untimely. It's the day after he's been convicted of rape. It's a short, an experienced judge understands this is going to be a short portion of an enhancement penalty, where there's going to be board of probation records, jail records, prior convictions, and that will ultimately conclude the trial. And that's why I think it's an abuse of discretion standard based upon Commonwealth versus Miller, Mott, and
But counsel, the defendant didn't ask for a continuance in order to proceed pro se. So what's untimely about the request? So they appear, from my recollection, they appear in October of 2016. Counsel says he's unprepared, and the defendant says, I want to represent myself. So I guess I'm not seeing what's untimely about the request.
What I would suggest to Your Honor is that it's untimely because we're in the midst of a bifurcated trial, where at the heels of essentially the sentencing enhancement portion that is
doesn't Kulesa stand for the proposition that the defendant isn't bound by the choice that he makes for the first part of the trial?
What I would suggest is that he's not bound by it, but there was the untimeliness, the equivocal nature of it, and the improper purpose of it were all reasons why this is an abuse of discretion standard, and the judge was well within his discretion to deny that request.
Why was it improper? I'm not understanding why it was improper.
He essentially wanted to raise a constitutional issue as to the
Okay, well, that goes to the, I mean, he's entitled to do that. It's not improper. And so why is it equivocal when the judge clearly understood him to be invoking his right to proceed pro se? The judge expressly said, I'm denying your right to proceed pro se. So why is that then equivocal?
I think it's well within his discretion to inquire as to why he wants to represent himself and why he thinks he should go without an attorney here, especially where the attorney's involved in the conversation.
Well, as your brother said, he can choose to fall on his sword if he wants to. He has that right. I don't see why we look to what arguments he's intending to raise.
I would suggest that the judge here is well within his discretion to say, and what is the purpose of this? Why does he want to proceed pro se? And does he understand? This is a person that's had outbursts, numerous attorneys, and has he's had a relationship essentially with the court, the judge, throughout this trial. And so why for this portion of it, this documentary evidence portion of it, do you believe you need to be pro se? Where are you going? Judges ask that to attorneys. Where are you going with this? And I think that's perfectly appropriate for a judge to ask, so that a just result it occurs, and that there's not that an appellate argument during a trial, or that in this case, for the defendant's benefit, that all he wanted to do was testify, and he was able to do that and explain that in his what he felt.
If we find that there is error or abuse of discretion, if you will, do you agree that we don't engage in any analysis of prejudice, that it is in fact structural error?
No. I would suggest to your honors, whether if it's an abuse of discretion sin, and I do. Sorry.
So, but what I'm asking is, if we find that there is an abuse of discretion, that there is an error, what is the standard that governs our analysis of prejudice?
I would say it's at that point, it's a harmless error standard. And if your honors were to find an abuse of discretion, I would ask that you consider whether under the circumstances here, it resulted in justice not being done. And
do you have a case that says the standard is harmless error for prejudice?
I would suggest that directly on point, no. But I would suggest Commonwealth versus Ruiz, 442 Mass, 826, 2004, it is instructive. I would also suggest that the Commonwealth versus Miller case is also instructive to this point, and on the whether it was an abuse of discretion. I would also suggest that, nope, that's all. I'd rest on those and my brief.
All right, thank you. Are there any follow-up questions? I see Mr. McGee, your time is almost up. Thank you both for your argument. The case is submitted and we will take it under advisement.
All right, we are live and recording.
And good morning, Ms. Lynch and Mr. Gauthier, and welcome to today's session of the Appeals Court, which we are conducting virtually, as you can see. From time to time, we do have some technical glitches. Hopefully we won't this morning, but if we do, we will temporarily suspend and put you back in the waiting room until we resolve the difficulties. So just be patient. Even though we are on Zoom, the same rules apply today as apply in the courtroom. As you know, you both have 15 minutes to argue. There is no rebuttal. We've read your cases and your briefs very carefully. So I would suggest that you get right to the heart of your argument to make the best use of your time. With that, let me just repeat the case name and number. It is 20P0394, Commonwealth versus Enrique Cintron. This is a Commonwealth's appeal, so I will return to Ms. Lynch first for argument on behalf of the Commonwealth.
It's
No?
not a Commonwealth appeal, Your Honor.
Oh, I apologize. All right, then I turn to Mr. Gauthier.
I
I'll let Mr. Gauthier go first. I apologize.
Good morning, Your Honors. May it please the court. My name is Attorney Edward Gauthier. I appear today on behalf of the defendant, Enrique Cintron. Mr. Cintron was convicted of assault and battery on a police officer and resisting arrest. Your Honor, the first argument we have today is we believe that the defendant, Mr. Cintron, was entitled to an instruction on self-defense for the assault and battery on a police officer, as well as unreasonable use of police force on the resisting arrest charge. Defense counsel did not ask for these instructions, even though she was alerted to do so during the charge conference. The closing argument of the defense attorney indicates accord with much of the officer's testimony. And there's testimony from the officer and there's testimony from a civilian witness. In the light most favorable to the defendant, which is the standard we use for this instruction, essentially the officer in this case approached the defendant, came out of the cruiser with his taser, did not tell the defendant why he was being placed under arrest, and then an altercation ensued. During this altercation, the officer deployed his taser multiple times and pepper sprayed the defendant. What's important, though, is that there is no refutation by the civilian witness that while on the ground, the defendant punched and kicked the officer. So the civilian witness disputes the officer's characterization of the beginning of the event. She says that the defendant went to a prone position and then was tased and the altercation ensued, while the officer says that the defendant first lunged. However, the civilian witness agrees that once on the ground, the defendant continued to roll around, continued to pull at the taser wires, and it does not refute the officer's testimony that Mr. Cintron, while on the ground, punched and kicked the officer. So,
could I interrupt you, Mr. Gauthier, though? But doesn't the witness, the same witness, say more generally when asked more or less what the defendant did? He didn't run, he didn't fight, and testified that he was compliant with the officer throughout. Isn't that also the case?
her testimony was generally that Mr. Cintron heeded the officer's order at the beginning. He went to a spread eagle position, and at that point, the officer first tased Mr. Cintron. From there, he got up, he ran away. The officer says that he ran away. The civilian witness says he was in a stupor, but in any event, he was moving away from the officer, at which point he was tased in the back. Also, the photographic evidence that's described by the officer shows that he suffered injuries consistent with being struck, scratched, kicked. So the jury looking at this evidence would have to believe that there's no doubt that this altercation took place. There was definitely an altercation between the officer and Mr. Cintron, and in the light most favorable to the Commonwealth. And now during the charge conference, the Commonwealth argues that based on the testimony of the officer, the defendant's not entitled to these instructions. But in reality, it's a totality of the evidence in the light most favorable to the defense. And in the light most favorable, the totality of the evidence acknowledges the existence of a physical altercation. There's no doubt that there was a physical altercation between the officer and the defendant, that the defendant engaged physically with the officer, and that although the jury found that the Commonwealth failed to meet its burden on the charges of attempting to steal the vehicle and kicking out the window and tasing, there was no physical evidence of tasing. It found him guilty of assault and battery on the police officer and the resisting arrest. But if they were instructed that the defendant is entitled to use reasonable means when a police officer is engaging in the unreasonable use of police force. My reading of the facts of this case and the closing arguments of both counsel, that's the only real potential defense to those two charges. There's no refutation of the punching and kicking. And in fact, defense counsel at page 119 of her closing reiterates to the jury that there is punching and kicking. So without a instruction on self-defense, without an instruction that the defendant is entitled to resist an unreasonable use of police force, the jury was really left with no mechanism by which to acquit the defendant on those charges.
Do you agree, Mr. Gauthier, that the defense theory at trial was that the events as described by the officer did not happen, rather than the defendant acted in self-defense?
I have reread the closing argument several times, and I can glean from that the obvious defense on the first charge is identity. But if you look at the recitation of the facts by the defense counsel in the closing, it's essentially describing all of the things that the officer did that were excessive. Exiting the cruiser with the taser already pointed, not telling the defendant why he was being arrested, tasing him repeatedly, pepper spraying him. Those facts are the facts that support a self-defense. The defense can't argue that the officer is wholly dishonest with his recounting of the facts and then expect the jury to believe that he did tase him, he did pepper spray him, he did all the things that defense counsel wants the jury to believe he did. I frankly left the closing argument after reading the closing argument, and I didn't know exactly what the defense was other than the standard defense of reasonable doubt. If there are no other questions on the first issue, the consciousness of guilt issue, I will acknowledge from the Commonwealth's brief. They point out that the consciousness of guilt instruction is probably not a make or break moment in this case. The jury clearly did not find Mr. Cintron guilty of many of the charges against him. However, we believe that the evidence simply was too lean. It was too weak. He's in a vehicle and he points. And as a result of him pointing, the driver of the vehicle went a certain way. And from that single instance, we got an instruction that the jury can infer, if it wants, of course it does not have to, it can infer that he had a state of mind that he felt guilt for something he had done.
May I interrupt, and I'm sorry to interrupt again, but does it matter in light of the fact that the jury acquitted your client of all of the charges for which he could have been feeling guilt at that moment, at least according to this case?
Well, yes, it is true that the defendant was acquitted of all of those charges. So the jury did not find proof beyond a reasonable doubt that he committed the driving offenses on the 26th. However, if they believe that he had a guilty state of mind or a guilty conscience at that time, perhaps they can then infer that during this altercation with LaFlamme, he's not as innocent as he purports to be. The defense made the argument that he was yelling for a camera. He wanted his friend to use a camera. He was threatening to sue. But if the jury believes that he has a guilty mind at that point, if it accepts that he has a guilty conscience, perhaps they would be less likely to credit the defense that he was essentially just an innocent guy walking down the street when he had an altercation with this officer. Again, I acknowledge from the Commonwealth's brief that this is likely not a make or break instruction to the jury. However, we do feel that the facts supporting it were very lean. And regarding the third issue, the Tui Rodriguez, The appellate courts are very, very deferential, of course, to the Tui Rodriguez instruction. There's case law that allows essentially, the only case I was able to find where an appellate court overturned the giving of a Tui Rodriguez type instruction was when it was given essentially as part of the jury charge at the beginning of the deliberations. However, in this case, I think it's pretty clear from reading the charge conference before the Tui Rodriguez instruction that the defense counsel wasn't really familiar with the charge, hadn't researched the charge, yet nonetheless went along with it. And we're talking about two different complaints, two different incidents, some complicated facts, 7 or 8 different fact witnesses, and we're giving a Tui Rodriguez instruction 3 hours in. And I don't believe that the statement from the jury to the judge, the letter they wrote, was sufficient to establish that it was a deadlock. The jury basically said, we've been doing this for a few hours. You know what? We're finished with most of our work, but we've got a couple of the charges that we're not so sure on. What happens if we don't reach a decision? They're not coming back and saying, Your Honor, we're deadlocked. We've done all that we can on this case. We just can't reach a verdict. We need help. They're just simply inquiring after a very short period of time. They're saying, Judge, what happens if we can't decide these 2 charges? So our position is that the Tui Rodriguez instruction was premature. If there are no further questions, defense would rest on the brief.
Seeing none, thank you very much. Ms. Lynch, when you're ready.
Good morning, Your Honors. May it please the court, Bethany Lynch, Assistant District Attorney representing the Commonwealth in this case. If it's agreeable to the court, I'm going to take the arguments in reverse order and very quickly address the Tui Rodriguez charge issue. I think that it's very important to recognize that it was the defendant himself who asked for this charge. It wasn't the Commonwealth. So the defendant didn't go along with this. It was the defendant who actually requested it from the judge. The judge, in reading the note from the jury says that they're struggling and they're to reach a consensus, and that struggle was impacting their ability to decide other charges as well. So the judge in this case, who has a great deal of discretion, found that 3.5 hours was a long enough time, and that the jury found the jury was deadlocked and unable to make further progress. So all parties agreed that the Tui Rodriguez charge was the proper avenue, and he gave the charge that was unobjected to. The language was correct. So I would suggest that there was no abuse of discretion here, especially in light of the fact that it was the defendant who requested the charge in the first place. So for him now to say that there wasn't due and thorough, when clearly at trial the defense counsel believed that there was, and that's why they asked for the charge, would just be an improper conclusion to draw. As to the consciousness of guilt argument, I think that obviously the Commonwealth's main point is that the consciousness of guilt instruction went to charges for which the defendant was wholly acquitted. And because he was wholly acquitted, even if it was incorrect in having given the charge, which the Commonwealth does not concede, but even if it was incorrect, there was no prejudice whatsoever to the defendant. Just very briefly, the charge was properly given. The defendant didn't just point. Based on the evidence that was before the judge for his consideration, there was sufficient evidence that the defendant was involved in a high-speed chase with this same officer days before, that the officer was following him, that the car turned and did sort of a U-turn. It was at an intersection where it could see the officer parked waiting for backup to come. And the defendant we can infer that the defendant saw the vehicle because he looked in that direction and it was an unimpeded view a block away. And then he pointed in the opposite direction, and that's the way that the vehicle went. So in light of that, the evidence both from the interaction with the officer on the 26th, thus the car chase, which ultimately he was acquitted of, but at the time that the judge was considering the instruction, that was evidence for his consideration. Seeing the officer parked on the next block and then turning in the opposite directing the driver to turn in the opposite direction was sufficient evidence for a consciousness of guilt instruction, and an instruction which ultimately had no impact on this trial because of the acquittal on the charges to which it related. Now I'll discuss whether, unless the court has any questions on those issues, I'll discuss the fact that the defendant's attorney was not ineffective in failing or in deciding not to request a self-defense and unreasonable use of force instruction. The defense in this case throughout was that the officer was lying. The officer was not telling the truth about the interaction with this defendant. And while it is true that the civilian witness didn't affirmatively disclaim the fact that there was punching, she also didn't say there was. She indicated that the defendant was compliant throughout, that he laid down, he complied with all requests, and the officer just came running out of the car when the defendant laid spread eagled for no reason and without provocation. The officer ran up and tased him multiple times. He rolled around. So there was nothing in her testimony that adopted the fact that the officer was punched. So I think that the argument that the fact that she didn't affirmatively disclaim it while testifying that he was compliant throughout is not a sufficient enough reason to say that we can accept that the defendant too argued that he hit the officer. The bottom line here is that this defendant in his trial, in his presentation of evidence to the jury, in his cross-examination of the officer, his entire focus was to disprove or to disallow the thought that the defendant struck the officer at all. He did not, according to the defendant's testimony or the defendant's witness's testimony, he did not strike back. He did not defend himself in any way. So there's nothing in either the Commonwealth's case which indicates that the defendant was the aggressor, the primary aggressor throughout the entire interaction. The officer did get out of the car with his taser in his hand, but he didn't wield the taser until such time as the defendant began yelling and shouting, and he bladed his body, he clenched his fists, he was in a very aggressive stature. And at that point, the officer instructed him repeatedly. I think at one point the testimony was it was up to 50 times over the course of this entire event. He instructed him to get on the ground and be compliant. And at no point was the defendant fully compliant, according to the Commonwealth's testimony. And the defendant was the aggressor. There's no evidence that the defendant was acting in a violent manner towards the officer in response to anything that the officer did. Now, I suppose you could try and cobble it together if you believe this one line from the defense case and this one line from the Commonwealth's case. If you put those together, possibly you could say, well, maybe if the jury just believed this but disregarded. But the problem with that is that that wasn't the defense that the defendant was pursuing.
Well,
and
defense counsel did say in closing, or did acknowledge in closing, that the defendant was punching and kicking the officer. So, at that point, what actually is the defense?
I believe that the closing argument wasn't as much as an acknowledgement of the punching and the kicking as it was a repetition of the officer's testimony. And the bulk of the closing argument was trying to undermine the officer's testimony about and his credibility, that it didn't make sense that the officer would have acted in this way, and that there was slight marks on the face, and was that really the fight of his life, and with very little marks in the photographs, and there was some things on the ground. So she spent most of her discussion of that argument, of that portion of her argument, was trying to undermine the credibility of this police officer and undermine the credibility of and to shore up the credibility of the defense witness, that the defendant was compliant throughout most of the testimony. Now, granted that possibly if she had asked for it, the Commonwealth's position is that she was not entitled, the defendant was not entitled to either a self-defense or an excessive force based on the evidence in this case. But the defendant's attorney didn't ask for it because that wasn't the defense she was pursuing. She was pursuing a different defense, and she did not want any evidence. There was no evidence not how I want to say it, that she did not want to acknowledge that the defendant was being aggressive towards the officer. Her testimony, also one other point, just a slight point that I'll leave to the court's reading, but my reading of the transcript at volume 1, page 115 to 116, I don't read it that there was any pepper spray ever deployed here. He had his pepper spray out. The officer testified that he returned the pepper spray. The defendant had his head turned away so that pepper spray would have been ineffective. So I don't believe there's any evidence that any pepper spray was ever deployed at the scene. There was no evidence about anyone needing any kind of medical attention or eyes watering or anything like that. So again, that is my understanding of the evidence. I'll leave it to the court if you have a different view upon reading it. But I would suggest that there was no pepper spray deployed here. So the only evidence is that the defendant, the Commonwealth's evidence was that the defendant was the primary aggressor. There was no evidence at trial that he was defending himself. The defense witness testified that he was fully compliant. And so there would have been insufficient evidence for the self-defense or the unreasonable use of force instruction to have been given.
So
therefore,
in the closing argument, defense counsel says defendant is kicking him and punching him repeatedly in the face right there, okay? Punching him repeatedly and kicking him, and you're going to get to look at that in the jury room. By that, I assume she means a video.
It's a photograph, and I would suggest that part of the testimony is mocking, because she was arguing that the police officer did not have sufficient injuries. So I would suggest that in reading from above that and down, that she's suggesting that, jury, you have a photograph of what the police officer looked like. And he's punching him and he's kicking him and he's doing all these things. And you're going to be able to look at that photograph. And she's arguing that, and you will see that can't be true, because
what's the photograph of?
It's a photograph of the police officer, his injuries.
Of the injury.
And
okay.
Yes, and the officer testified that this was the fight of his life. And at one point in the closing argument, the defense attorney is mocking him. He's like, "Oh, it's the fight of his life." He's crying on the stand, and my client is punching. I'm sorry, noise in my house. The defendant is punching him and kicking him, and you'll see the picture. And you make your own decision. So I would suggest that it's less an admission that it happened, as it was a mocking of the testimony, and therefore implying that it was untrue, and that the officer, there may have been some sort of scuffle, possibly, because the officer did have some marks, but the entirety of that argument is implying that the officer's marks are insufficient for the fight, this horrendous fight that he claims to have engaged in with the defendant punching him and kicking him, punching him in the face. So I suggest that it wasn't a admission of a punching of the officer, and I would suggest that there was never an admission, and that was the defense. The defense was that this defendant did not fight back. He didn't defend himself. And
so the video that's in evidence was taken after the actual altercation?
It was, and it's my understanding that it's a very brief clip, and it's at the very end after the defendant is already on the ground in custody.
Okay.
It's not, apparently it's not that helpful of a clip. I did not review it from the evidence, but from the description in the trial transcript, it does not appear to be anything dispositive. So that would be my bottom line, is that the defense attorney made a reasonable strategic decision not to ask for a self-defense instruction, even in light of the fact that it was mentioned. She still did not request it, because that was not the basis of her defense. And she put on a witness who said that he was compliant, and that it was the police officer who was the only aggressor in this. And that's one version of the events. The other version of the events is the police officer's version, where the defendant was the sole aggressor. And at that point, he wouldn't be entitled to a self-defense instruction anyway. So in light of that evidence, I would suggest that the defense attorney made a reasonable strategic decision not to pursue that as a defense, and instead to pursue a defense of fabrication on the part of the police officer. And I would suggest too that the defendant was very successful in most of this. He was acquitted of 8 out of 10 of the charges. So, but for these 2 charges, the defense did a very good job. So I think that's really the bottom line, is that there was no ineffective assistance of counsel here in light of the reasonable strategic decision that was made by counsel. If the court has no further questions, I would rest on my brief and ask that the convictions be affirmed.
Thank you very much. Seeing no further questions, I want to thank you both for your arguments. They've been very helpful. The matter is submitted and taken under advisement.
Thank you very much.
Thank you.
I guess my work here is done.
All right, we are live and recording.
The next case on our list this morning is case number 2020 P100, Catherine J. McMacken versus Daniel D. McMacken. You may begin.
May it please the court. My name is Valerie Robin. I represent Catherine McMacken, who is present with me for the Zoom oral argument as she's watching this via the YouTube channel. After more than 25 years of marriage, Kathy McMacken was entitled to her equitable share of Dan McMacken's ownership interest in the McMacken entities. The primary asset of this long-term marriage was an ownership interest in a family business known as McMacken Technical Services, MTS, that generated millions of dollars. Kathy's husband, who had worked in the unique family business for almost the entire marriage, was an equal owner with his dad, aunt, and uncle. This case challenges the fundamental principle in a divorce that property division between a husband and wife is constrained by fiduciary considerations, and that fair value in a divorce proceeding should embody the same fairness found in valuing minority shareholders' interests in a freeze-out or in a shareholder's appraisal rights situation. Here, Kathy was denied the ability to do any due diligence in analyzing and valuing her husband's minority interests in the closely held family business. What was known was his company annually shifted significant monies in a single transaction called a management fee to a company owned by the dad, uncle, and aunt called McMacken Corporation. This was anything but an arm's length transaction. To put this in context, this management fee was $2.2 million and represented 63% of the sales and equated 70% of the reported expenses. And in the years of the divorce, MTS showed a substantial increase in the management fee, paying the largest management fee amount to the dad, uncle, and aunt's company, despite a drop in the reported sales from prior years. Also, at the time of the divorce, it was reported that PPC, another McMacken entity, which the husband was also an owner, was dissolved, while other McMacken companies of the controlling shareholders, that is the dad, the aunt, and uncle, still existed. These were MPS, PSNT. All of these companies that made up the McMacken entities shared the same physical location. They had a commonality of clients, officers, directors, employees, and of course, similar shareholders. The controlling shareholders company, McMacken, had all the material records for MTS, PPC, and these other related McMacken companies. Everything was run through McMacken. That included sales and expense records, payroll, utilities, and basic expenses for the husband's company. Without the cooperation of Dan McMacken or the court, Kathy did not know any of MTS's basic expenses, such as rent, payroll, utilities, but only this large management fee existed, which was paid to McMacken Corp. As such, her
that your principal challenge to the management fee or the opacity of the financial statement goes to the discovery order entered by Judge Phelan early in the case.
That's correct. This started with those June 2017 orders. There was 2 orders. There was an order that was a result of a motion to compel the husband to provide this information, because after all, he was a minority shareholder and he also was an officer and director in these companies, and he also had certain obligations to produce certain records. As I read
the papers relating to that discovery motion, the motion to compel, as to the key piece, on McMacken itself, the husband was not an owner of that entity.
The husband is not an owner of the McMacken Corporation.
And the McMacken Corporation is the entity that sets and receives the management fee, which, as you noted, is quite a significant element of the annual expense structure of MTS.
That is correct. It not only sets and receives the position that was taken throughout and consistently by husband, which is the error of, which we would argue is the error of law, is because he had no ownership interest in the McMacken Corporation. Therefore, he wasn't entitled to these records. And that simply is not the law as a minority shareholder. You had a situation where his company, you had the controlling shareholders who were not involved in an arm's length transaction. And going back, the SJC over 100 years ago said, anytime you have these kinds of transactions where you have related, what we'll call related parties, is they have to be looked at with suspect. I mean, that was the DeMoulas case. That was even this court in overnight said, don't just accept it. Look at this.
What authority did the husband have to compel the production of these materials from the McMacken company?
The authority that the husband had was as the basic fact that he was a minority shareholder in the company. He had the right to the books.
He was a minority shareholder in MTS, but not in McMacken. I'm talking about access to the records of McMacken.
Well, as a minority shareholder in MTS, he had the right to go to his company to ask for those records as it relates to MTS. Those controlling shareholders had the ability to get that information. Also, moreover, we can't ignore the fact that Dan McMacken was an officer and director in these other related entities. So he had access there as well. So you had a situation, if you turn this on its head, if you imagine that my client, Kathy McMacken, was a 12.5% owner, Kathy McMacken, her husband was 12.5%, and the other controlling shareholders, she, as a shareholder in MTS, would have the ability to look under the covers, so to speak, at this management fee and to get information, because after all, it was with the controlling shareholders company.
Just by way of context, and I know this is in the record, I don't recall the progression. You alluded earlier to an increase in the management fee over the course of the divorce proceedings, but I don't have that at my fingertips. What order of magnitude are we talking about? What was it, for example, in the year before it became 2.2? What was it the year before? What was it the year before that?
It was listed in the record, and it's also listed in the brief. In terms of the order of magnitude, it was about a 20% increase in the year of the divorce. What was also significant was the sales in the year of the divorce, or the last years that were provided, which was the 2017, were decreased. So in other words, there was no real correlation that if sales went up, the management fee should go up, or if sales went down. And
well, as I understood things, the way the management fee was structured was really reimbursement for back office expenses and other expenses. So that sales, I mean, it's unfortunate when sales don't increase alongside a corresponding increase in expenses. But it could be that there were additional employees or other expenses that simply fed into that management fee.
There absolutely could have been, but what's also equally as important is you still had a minority owner, you still had a spouse who's trying to value a company who had she didn't even know what the payroll was. She didn't even know even the sales records.
Well, how could she not know what the payroll is? Isn't that, I mean, the records of MTS are all available to her, right?
In theory, the records of MTS were available, but payroll was run through McMacken Corporation. So McMacken Corporation had the payroll for all the employees that it allocated to MTS. However, that information wasn't provided. Instead, what the husband provided and what MTS provided, it said, we'll give you the in essence, the W-2 for Dan McMacken and for the other, for the aunt, the uncle, and the father. But that didn't include the other employees. There was no breakdown, that the expert had no ability to track the breakdown. And look, as a practical matter, if the management fee was a valid management fee, is that was a position that the husband should have presented, and Ms. McMacken should have had the opportunity to challenge or to look at. But all that information wasn't made. Imagine buying a company where you don't know the breakdown of what the payroll is. You don't know the breakdown of the rent. You don't know any of this information. All you know is what is reported in the first document, which was before Judge Phelan, which was McMacken Corporation's, or the entities filed a paper, and that's in the record. There was no affidavit. There was just this general statement that said, basically, they're like a human resource company. And again, we're looking to try to divest the wife of her ownership interest in this company. It's critical that she has access and she has the opportunity to then have her expert rely. This expert, incidentally, Kathy McMacken, he had done over 7,000 valuations. And for the first time in his 40 years, he was unable to provide a value. That's what Kathy McMacken was faced with.
So we reviewed the judge's decision for abuse of discretion. And when I took a look at your May 2017 motion, it's not limited to asking for documents in order to ascertain, to break down the management fee. It seems to me it's a very broad motion based on allegations of self-dealing, what have you. The McMacken companies had objected to your discovery, to the requests on the ground that they were overbroad. So did you, in response, ever, did you offer to limit the category of documents you were requesting to those that concern the management fee?
Specifically in the motion itself, and I recognize what the court has just asked me about limiting the broad, I specifically highlighted the issue with the management fee. That's right there.
It was one sentence in a larger motion asking for pretty broad categories of documents. Reviewing that for abuse of discretion, it's hard to say that denying those broad categories of documents would be an abuse of discretion. So did you, in response, offer to narrow the request?
Well, throughout the case, the request not only was narrowed, but each time it was challenged and responded by the husband with the same situation.
Well, but there was an issue that arose later on concerning the timeliness and the motions that were made outside the discovery period. I mean, to Judge Shin's question, it would have either at the hearing itself or with a renewed motion on seeking a more limited production, it would have been available certainly to address the concern over breadth.
Well, certainly, and I was the trial counsel, certainly in hindsight, you can look back. At the time with Judge Phelan's order, it seemed pretty clear that I wasn't entitled, that Kathy McMacken wasn't entitled to those records.
How so? I mean, I used the word opacity before in reference to the management fee, but Judge Phelan's endorsement doesn't give us a lot of insight into what he was thinking.
It doesn't give a lot of insight. And the only insight that I then had is then when I was shortly before trial, where I went in on a motion of limited leave because I thought I had to ask for permission, was the situation where Judge Cronin said, and not strike that, before Judge Cronin, is my friend here actually argued and said, this is exactly the same information that they're asking for all over again. And if that wasn't enough, I issued trial subpoenas.
No, but at that point, you're on the eve of trial, and there's been no discovery around this thing. I mean, I think the question really is, it sounds like there really wasn't any effort made to zero in on the management fee back at the time when the original discovery was sought.
Well, I beg to differ in the sense that I also then issued additional subpoenas in June of 2018, specifically to MTS, asking for certain records, because what was left was with the impression, and I realized, was that the records, and in fact, this was argued through trial, was left with the records of McMacken Corporation were off limits. So again, I'm looking for, and it was a little bit of a circular argument. I'm looking for records relative to MTS, and all the records of any critical piece of information are being held by the McMacken Corporation. So you had it, putting everything aside, when you issue trial subpoenas, then it was, Your Honor, she should be sanctioned because this was already ruled upon. She's not entitled to these records. This is the same request. And those which are also in the record were just as specific, looking for the management fee. If you have no questions, I simply would offer that two things. One is regarding the affidavit for attorney's fee that was recently submitted yesterday. I would suggest that this is just simply more, that shows the husband seems more interested in money than treating the wife with fairness. This case presents a critical issue in divesting marital interest in a closely held business proceeding. This court has the opportunity to clarify that fair value in a divorce valuation means fair value of the spouse's share in the business, and fair body embodies the same fairness found in a minority shareholders freeze-out situation. So I'd ask that, I'd rely on my briefs. I'd also ask the court to look at JS versus CC, which talks about the burden. Thank you.
Thank you. Attorney Friedman.
Good morning. May it please the court. My name is David Friedman on behalf of Dan McMacken. I think the court has honed in on the discovery issue as I was to present it. All issues of the brief can really be put into one of two categories, either the challenging of the discovery orders or challenging of the admission of expert testimony as to the value of the business. As to the discovery order, there was the June 2017 order that you've discussed already. At the time, these were very broad requests, not specific, of 5 different business entities, in which it's undisputed that Mr. McMacken only has a 25% interest in MTS and no other business. It was I was not present at the hearing, although from reading the opposition and reading the underlying motion, it's clear that there was privacy issues raised. And ultimately, it's not whether one judge may have done something different on a different day, but rather did the Judge Phelan, who was the judge at that time, abuse his discretion, and more so, did wife show prejudicial error as a result of that abuse?
Well, I have to say, in light of the significance of the management fee as an element of the balance sheet and operating statement of MTS, it's a little hard for me at least, to understand why in the ordinary course that would be denied on concerns of privacy, where the relevant owners of the related entity are all close relatives. I think it's a different question whether it was a victim of being surrounded by a bunch of other requests that were in fact overbroad. But standing alone, it's hard for me to understand how a trial judge would justify the denial of discovery into the management fee.
Correct. And perhaps a different judge, had that issue been pinpointed, would have ruled differently. Although ultimately, the question is, as a result of the abuse of discretion, has there been prejudicial error? And there's no evidence showing that.
Well, how could you demonstrate prejudice if you can't get the information?
Well, there's 5 years, respectfully, there's 5 years of tax returns well before this divorce was filed, showing the existence of a management fee. The record does reflect, to respond to an earlier question, that MTS did hire additional employees in the later years. I believe that's in trial transcript. But this is something that's historically existed, and we are not to presume that it's incorrect. So nothing happened following the June 2017 orders until a hearing 13 days before trial.
Let me just imagine a hypothetical sale. The husband decides he and the other owners decide they no longer want to own this business, and they enlist the assistance of a broker to help them find a buyer. And the buyer comes in and they put that under whether it's a stock sale or an asset sale, they put that under some form of agreement. It's going to include some due diligence. The buyer is going to want to know more about the management fee before that money is ever going to change hands, right?
I can only speculate, Your Honor. It's very possible.
You can do more than speculate, Mr. Friedman.
It's very possible. No, it's very possible. But again,
it's unrealistic to imagine that any arm's length third-party buyer would purchase this company without access to that kind of financial detail about the company's operations and expenses.
And unfortunately, that documentation was not asked for until 13 days before trial to the court. And the court, exercising its right to manage for case management, denied that request, saying that you've had that opportunity. This case went on from February 2016, and wife didn't hire an expert until May 2018. Ultimately, again, as I said earlier, had the question been brought to a different judge on a different day, absolutely, but wasn't an abuse of discretion, and was there prejudicial error? And it is common practice, as our expert testified, that he relies on the financial documents of the company, including the tax returns, which he did. And then ultimately, waiting until 13 days before trial, again, the judge was acting within his discretion. As to the valuation of the business, as to admitting husband's expert testimony and report, the wife's brief does not outline the foundational requirements for admission of expert testimony. However, trial testimony will show that Mr. Bello was offered, that we reviewed his CV, that he looked over substantial documentation, and based on his experience, he was able to come up with a value that the judge found acknowledged his methodology, that both experts agreed upon an income approach, and even wife's expert said had he accepted the value, the number for the management fee, he would have come up to the same value as Mr. Bello. So ultimately, Your Honor, the court did accept Mr. Bello's testimony as reliable and made findings. As to the court's findings, again, that would be a clearly erroneous standard. And it was presented, this numbers come directly from the tax returns. And I don't know how the court could held for their findings as to the value of the husband's 25% interest be clearly erroneous, where it's drawn directly from the documents of the business. My sister does reference our request under Rule 25. Your Honor, there are numerous, I guess I should start under the Avery v. Steele case. It says inappropriate arguments and unsubstantiated statements in a brief may infect an otherwise meritorious appeal so pervasively as to make it frivolous. Our brief does identify several things, including the introduction section put into the brief that's unsupported by law or fact. There's references to corporate filings 10 months after the date of trial in the brief. There is testimony presented that was objected to, and our objection was sustained, that was included in the brief.
I think I have a handle on the grounds that you say warrant an award of fees. I will say that I think this is a first in my appellate career, which goes back a little ways, of actually receiving the detailed breakdown of the fees requested before we ruled on the fee request itself.
Well, I want to make sure that all the information was available to see the reasonableness of our fees.
We have a tendency to ask that information if it becomes an issue.
No, I can resubmit it if you would like it again.
We have it. I'm just making an observation that it's not typical for someone to forward the basis for the amount they want before they've been told they're going to get the amount.
Thank you. It's good to know.
Okay. Anything further?
No other. If the court is satisfied, I'll rest on my brief.
Thank you both. The case
3160B, which is the medical malpractice tribunal statute in Massachusetts. We believe for the following reasons that the judge, the lower court judge, should have allowed prospective effect only of the decision. In particular, the Supreme Judicial Court defined language within the medical malpractice tribunal statute that had been previously undefined. And that's the language that requires the posting of a cash bond or its equivalent in the event that the tribunal should find in favor of the defendant.
You're familiar, I take it, with the general rule on retroactivity on a question of statutory interpretation?
Yes, Your Honor. We had argued the factors of several cases, but one in particular, McIntyre versus the Association of Financial Services Company. This is a 1975 case that sets out the principles to determine whether an exception to retroactivity is warranted. We feel that these principles fall in the favor of Mr. Rossini.
Ordinarily, when the Supreme Judicial Court wishes to make its ruling on a statutory interpretation prospective only, it says so in the decision itself, right?
Well, the Supreme Judicial Court in Polanco was silent on that issue.
I understand that. Can you point me to a case where the Supreme Judicial Court made something prospective only, but didn't say so in that case? While you're thinking, I'll ask if you are familiar with a case that the appeals court recently issued just this past summer, Della Russo versus PNC Bank, regarding the same question of retroactivity and the statutory interpretation.
I'm not familiar with that case.
Well, I'll commend it to you. It addresses the point fairly thoroughly, and well, anyway. Okay, if we get past the question, if we agree that, or if we disagree with you that Polanco should be applied retroactively, if we conclude it should be applied retroactively, you've got a couple of other arguments, including abuse of discretion in failure to, or the denial of your 60B motion.
Yes, Your Honor, but if I may address the factors in McIntyre just briefly.
Okay.
So without a specific, order from the Polanco court, the McIntyre factors we're arguing apply, which would mean, number one, the lower court should have analyzed whether the extent to which the decision created a novel or an unforeshadowed principle or a new rule of law. And in this particular instance, the definition of cash or its equivalent was not previously decided by the Supreme Judicial Court. So in that sense, it was a new or novel principle of law.
How was the analogous situation handled in the context of bail?
That would be in the criminal side, Your Honor, and this was a civil case. So
I understand that, but it involves the posting of a bond, and it's one place that one might look for guidance on how the courts would view a bond requirement and the equivalent of cash to a surety bond.
I don't believe the Polanco court looked to the cash bond
They didn't do so expressly, but I'm just asking the question because if you're looking around for possible ways to frame the question, that would be one place to look, wouldn't it?
Perhaps, but the cases seem to break out.
Do you know the answer to the question, I guess, before we move on? Do you know the answer to the question to how it's handled in the bail situation?
Well, I think the issue would be a constitutional question, so that would create a bit of a different analysis for the court because because of the constitutional rights of the defendant. Here we have a civil case, so it would be a different analysis. That's my reading of the cases.
That always comes to my mind when I'm getting this argument on retroactivity is the party in Polanco had no prior notice of what the statutory interpretation was going to be either. Why should a different party have the benefit of avoiding that rule when the words of the statute were a constant throughout?
Well, that gets to the remedy, or my other argument, which was that, we asked for a cure, which would be allowance of an extension of time to file a cash bond.
The time to file is created how? By statute, right?
It is, and we complied with that at the time prior to the August of 2018 Polanco ruling.
Well, I understand, but when you're asking a court to enlarge a statutory deadline pursuant to Rule 6, there's a fair body of case law out there that says that they are not allowed to do so. And you raised that request for the first time after your motion was to dismiss was, or after the motion to dismiss was already entered.
I did raise it at oral argument as well, in the sense that I asked the court for a cure at that point.
At the argument on the equivalency of surety bond, you made the offer at that hearing?
Yes, I requested to cure at that hearing, and that was on the motion to strike the bond, as well as the motion to dismiss. It was two issues brought up in one.
As I recall the sequence, there was a motion to strike, and the papers at least don't show any offer to post a cash bond or request to be allowed to do so. Then there was a motion for reconsideration, still silent on posting a cash bond, and then after entry of judgment, there was a 60B motion. And it was only in the 60B that I see that you asked for the opportunity to post a cash bond.
That's correct, Your Honor, on the papers in the 60B motion, but on oral argument during the motion to dismiss, I brought up the fact that given the timing of the ruling and the fact that we had a meritorious claim, so that it would coincide with the meaning of the medical malpractice tribunal rule and the bond posting rule. In other words, our case is not frivolous. That was shown.
Where is this exchange in the record? I don't think I have it. I don't think the record includes a transcript of that hearing, does it?
It does, Your Honor. And if I may be indulged for a moment to look at my papers.
That's 147. That's not the motion to strike. That's just the
Counsel, it's at record appendix 153.
Okay, thank you, Your Honor. So shall I continue, Your Honor?
Please.
So the other factors of McIntyre, which I also brought up in oral argument, was the fact that the retroactive application does not further the purpose of the new rule. So as I mentioned, I think it's well known that the purpose of the medical malpractice tribunal is to exclude frivolous claims. We had two expert opinions on the case that set forth the standard of care, that the standard of care was breached by defendant Dr. Jagadeesan, and that there was a meritorious claim. The other factor was the likelihood of hardship or inequity that would follow retroactive application. And in this case, we have at issue the plaintiff's right to a civil trial in Massachusetts, which is under Article 15 of the Massachusetts Constitution. And that deprivation of that right in this case would be inequitable and cause hardship. And so moving on in my argument, the motion to dismiss the contract claim was objectionable. The plaintiff had a plausibly reasonable entitlement to relief under 12b-6. All reasonable inferences of factual allegation should have been awarded to the plaintiff in the plaintiff's favor at the motion to dismiss phase. Facts in the record suggested that Dr. Jagadisan placed profits over patient care, which was pled in the complaint. It was suggested in a strong inference that the treatment provided by Dr. Jagadisan in part was not necessary. This was a breach of implied contract of good faith and fair dealing. Dr. Jagadisan testified in her deposition that she was, quote, expected to produce productivity, and she didn't want that kind of pressure for productivity. She also stated that as a physician, when you're employed and they give you a salary, they expect you to have a number of charges and bills done for them to receive or collect money that they are paying. So this is a significant suggestion that some of the treatment provided to Mrs. Rossini was unnecessary. That caused her economic damages, as we've alleged. And citing Colton versus Beth Israel Deaconess Medical Center 2004 case, contract-based claims are not subject to the tribunal.
I want to go back just for a moment, if I may, to the your challenge to the tribunal's ruling itself. Does that challenge survive the posting of the bond that you put up when the adverse ruling still came out? Does the posting of the bond, even though it was inadequate under the statute, did that operate as a waiver?
I believe the cases hold that the tribunal ruling can be argued at any point further in the proceeding. So I don't think it's waived.
Even when the bond is posted?
Yes, even when the bond is posted.
I was unaware of that.
And we feel like the tribunal on that subject was paid too much weight to the facts, did not read the evidence indulgently in favor of the plaintiff, which is the directed verdict standard. And that the tribunal exceeded the causation requirement and should have applied the standard that the directed verdict standard of causation, which is that it's enough to adduce evidence that there is a greater likelihood of or probability of harm to the plaintiff than not. And that was certainly suggested and stated by Dr. Pingree, who was our original expert in the case, who had to leave the case for family reasons. And I would request leave under Appellate Rule 16.1 to provide the court with, I believe it was the Della Russo case.
We have the Della Russo case.
Okay, thank you.
Attorney Visser?
Good morning, Chief Justice. May it please the court. My name is Christopher Visser, and I represent Dr. Jagadisan in this matter. I'll start by first speaking a little bit about the Planko case. I think the Planko case is pretty clear. It interprets the medical malpractice tribunal statute in Massachusetts, which requires the posting of a cash or a cash equivalent bond. I think all along since the introduction of the tribunal statute, it's been pretty clear that failure to post such a bond will result in dismissal of the case after 30 days. That goes all the way back to the Austin v. Boston University Hospital decision by the SJC. And I think that's the situation we're faced with in this case. The proper bond wasn't posted and the court properly dismissed the case. Speaking along those same lines, I think the primary issue potentially that my brother counsel has with the Planko decision is the retroactivity of that. I agree that he talked about the McIntyre case and also the Supreme Court case, Chevron case, which does lay out a test to look at retroactivity of a decision. I think I disagree with him that such test is to be taken by the trial court and not the appellate court. I think the test is laid out for the SJC in this situation that if they chose to, they could undertake their own review and decide on retroactivity of a decision. I think that furthermore, if you look at the subsequent case law, and including actually McIntyre, there's a general concept that if a decision in the underlying case, if in this case, in the Planko case, has retroactivity in that case, then it applies to all other pending cases the same way. And I think in this, there's just no doubt that there's any exception to the general rule that retroactivity of the decision applies to our case here. And that the courts applying those concepts properly denied or properly allowed the motion to dismiss and strike the surety bond. I think if you look at some other cases, I think the Eaton case was cited by my brother counsel. That was a case where the appellate court did take a review of retroactivity and made a unique determination in which they applied the ruling in that case retroactively to the case at hand, but did not in future cases. And again, that was a determination made by the SJC. It wasn't a determination made by the trial court. But again, like I said, I think there's several Massachusetts cases. McCormick is one of them that again stands for this idea that once a decision is made, especially interpreting a statute, that it's retroactive, it goes back, they're interpreting what the legislature meant by that statute at the beginning of when the statute was enacted.
I take it you're not familiar with Della Russo either?
Your Honor, I'm not. I know you mentioned that case.
Okay, it's okay. It just came out in I think in June or July.
Yeah, Your Honor, I'm not sure if Della Russo, if the facts are similar to this case or if different, but.
Well, it wasn't a medical malpractice case, but it was a question of retroactivity in the context of the statutory interpretation.
Okay. If the court would like, I certainly would be willing to review the case and supplement my brief.
No, that's okay. I mean, it's out there and it applied previous law, but I just thought that if you had something to say about it because it's the most recent discussion. But that's okay. That's okay. We don't need it.
Okay. Thank you, Your Honor. Next, I'll discuss a little bit about the plaintiff's contract claim. I think the contract claim in this case squarely falls within the purview of the Medical Malpractice Tribunal. As long as that contract claim falls in that purview, it is obviously subject to the bond. It's subject to the same requirements, and it also can be properly dismissed as it was in this case. I don't think there's any real dispute. If you look at the complaint itself, the allegation against Dr. Jagadisan was that, and this is in the contract claim, the only allegation against Dr. Jagadisan was that she failed to provide reasonable, necessary, and competent services to the detriment of the decedent. Dr. Jagadisan's an attending physician in this case. The only services she was providing to this patient was medical services. I think in that situation, and it's clear from the case law that anything arising out of anything that's a treatment-related claim is subject to the tribunal. This is distinguishable from the Kotlin case, which the Kotlin case involved many different aspects, but included claims against security officers and different things, which appeared to be a situation that a patient was terminated from care due to non-medical related reasons. And in the Kotlin case, they determined that breach of contract claim, which is a question of law, whether there's a duty owed to the patient that prevents them from terminating care, which I would submit to you is different than the situation here, where it is indeed a treatment-related claim. I also think that, we can look at the Lamley case, which is a mass appeals court case. And that is sort of an interesting case, that in the sense that it discusses the idea that all treatment-related claims are to be the purview of the tribunal. But it also says that you can also look at the plaintiff's complaint and the damages sought in that complaint to give you an idea if that contract claim is treatment-related. And I think in this case, it's very similar to the Lamley case, where it is clear that the type of damages sought by the plaintiff in this case are treatment-related, tort-related type damages. And you can look at that at in the amended complaint. I think the court in this case was properly applied their discretion in denying Mr. Federico's Rule 60B motion. I note as an initial matter, I think if I'm reading Mr. Federico's brief appropriately, I think the only issue he really brings on appeal is the under Rule 60B-6. The brief only argues that he's entitled to relief under that provision. I think certainly in the record appendix provided to this court, there's nothing in that record appendix that would give this court the ability to make a determination that the trial court abused his discretion when denying that motion. I think, especially in a situation where, I think the primary argument is that here it was impossible for him to comply with the statute. I think this ignores obviously prior, and I understand the presidential value of them, but the prior Superior Court case holding that a surety bond is not appropriate. It also ignores, we cited that it was Sosa case in which there was an appeal, and at least the court didn't address the appeal directly, but at least the appeal noted that the surety bond was struck in the Superior Court, and that the case was up on appeal and ultimately decided on other issues. I think given that information, I think it was clear that that the plaintiff was on notice that surety bond is not appropriate under the statute, and that the proper bond should have been posted. Certainly, I think that if the intention of the plaintiff was to attempt to cure it, he would have needed a proper motion under Rule 6, and then that would have been again left to the trial court's discretion to determine if that was if leave should be granted in that situation. I think if we come up with a situation in which we set a precedent that on a Rule 60 motion that a plaintiff can sort of make a last-ditch effort to cure whatever issue was underlying the motion to dismiss or any other type of dispositive motion, I think that would be a bad precedent, and it certainly would not result in people attempting to comply with discovery orders or post proper bonds or any other kind of issue where you would have a situation that you could attempt to cure after the fact.
You want to talk at all about the adequacy of the offer of proof and the propriety of the tribunal's ruling?
Yes, I think, well, first of all, I think given the record in front of the court, we obviously argue this in our brief, the offer of proof is not submitted to this court. The medical records that were part of the offer of proof are not part of the appendix. I don't know how the court can evaluate the offer of proof without the offer of proof. But I'll address, similar to my arguments in the lower court, I think Dr. Ingre's opinion is insufficient in this case. The sole standard of care opinion against Dr. Jagadisan is that she failed to document informed consent. I think the opinion even probably falls short in opining that she failed to obtain informed consent, but that's not necessarily important to the argument. But the real opinion is the standard of care was breached by her failure to record informed consent. And I think particularly troubling with that is that if you went through the record, there was numerous places where informed consent was documented, and including when the specific drug.
We don't, but I guess we don't have that because we don't have those records. So you say in your brief that that there was a written informed consent signed on January 9th, but there's no record citation for that. I take it that's because that's not part of the record appendix that we have.
Right, and the burden would have been on the plaintiff to substantiate his.
Right, but I mean, we can't, just as we can't evaluate the offer of proof, we also are not in a position to assess your representations about what was in it.
Well, I think you can, I guess you can accept it to the extent that it's covered in the oral argument that is part of it, the transcript from that, which addresses those citations. But you are correct. You don't, because the offer of proof wasn't included in the record appendix, you don't have that ability.
I didn't see it, and maybe I missed it. I didn't see a reference to a written informed consent in the transcript of the tribunal.
I think that's correct. I think I referred to several pages. I didn't specifically refer to that, although I did multiple times during the oral argument refer to several other that I didn't specifically.
Well, yeah, there was a fair amount of reference to verbal conversations and exchanges on the use of trazodone with the daughter-in-law, conversations with the daughter-in-law concerning the use of trazodone, but I didn't see any reference to a written informed consent signed.
Again, I think you're correct, Your Honor. I didn't specifically refer to that, but I did refer to, without citing specific pages, refer to that there was multiple places where informed consent was documented, in addition to the ones that I cited specifically. But the informed consent, it was signed before the start of the trazodone. It was signed by the healthcare proxy, and I think if the expert is going to offer an opinion that is in contradiction to the medical records and the offer of proof, then that is an insufficient opinion. His opinion has to be rooted in the evidence, and there's no indication that Dr. Pingree's opinion was rooted in the evidence in this case.
Going to the substance of the tribunal's ruling, as I read the exchange at the presentation of the tribunal, the question of causation pointed out that the opinion did not cite the administration of trazodone as being outside the standard of care, or explicitly tie it as the cause of the fall.
Correct, Your Honor. I think that is correct, that the causation opinion in this case, to the extent that there is one in Dr. Pingree's opinion, is just it's a conclusory opinion, and it doesn't directly link the medication to the cause of the death, which obviously you would need in the tribunal statute. I think, along those lines, if you look at the Cooper case, that's what I would probably rely on the most. I think that's the clearest case as far as the importance that the expert's opinion is rooted in the evidence, that it can't just be a standalone letter that essentially ignores the facts of the case. I mean, I understand that we can't challenge the credibility of the facts, or we can't challenge the facts themselves, but at least the expert's opinion needs to be rooted, or at least be consistent with the medical record. I think if you hold any other way, you obviously create a situation where any expert at a medical malpractice tribunal can ignore any part of the medical record they so choose and offer an opinion, which would obviously create a problem. I think for those reasons, I think that the tribunal finding was appropriate. As I mentioned earlier, I don't think that this court really is in a position, given the appendix, to be able to properly review that tribunal decision, but I would encourage the court to affirm all decisions from the trial court. And if there's no other questions, I'll rest on the remainder of my arguments on my brief.
Thank you both. The case is submitted.
Thank you, guys. Thank you, Your Honor.
All right, we are live and recording.
The last case on our list for hearing today is case number 2020 P209, Kevin McWillie and another versus Kathy Belfie and others. You may proceed.
Thank you. Please, the court, my name is Henry Goodman. I represent the plaintiff appellants, Kevin McWillie and Spencer Rhodes. And This case involves many issues, as you've probably seen from the brief. And I would like to start off with the derivative claim, the ruling by Judge Nickerson, wherein he indicated that he dismissed several counts because we did not send notice to all the unit owners. We did send notice, as you can see from the appendix, we did send notice to the trustees, but not to the unit owners. And it's my opinion that as a matter of law, the unit owners were not entitled to notice because legally they weren't entitled to it.
And you say that despite the discussion of that topic in Cote v. Levine?
In spite of that, Your Honor. If we take a look,
Levine was wrongly decided.
Not wrongly decided, but on the facts of this case, inapplicable in part for the following reason. And I think the first thing we have to look at is the case of Barish versus Bornstein and other cases like that, wherein the Supreme Judicial Court has said that unit owners cede all control of the common areas and facilities to the board as though the board was the unit owner thereof. Now, if we look not so much at Cody, but at Harron, by the way, I also would indicate Strauss versus Oyster River Condominium Trust said that as well. But in any event, in Harron, I think the purpose of the rule is to give notice to those who have the ability to do something. And in this particular case, the unit owners would not have the ability to deal with any of the issues present in this case because they were all trustee issues. Furthermore, the idea that that we would have to give notice to people who owned units in this condominium since 1988, when some of these matters first occurred, and heading forward to this date where unit owners had sold units, there were new unit owners that came in and so forth.
Mr. Goodman, why shouldn't the unit owners be viewed in this context as the equivalent of shareholders in a corporate derivative suit?
Because shareholders in a corporate derivative suit have the ability to vote on certain things, which in this particular case, with regard to the items that are here before us today, they have no ability to vote on any of the things that we're going to be arguing about.
Really, the shareholders collectively have no authority to direct the condominium trustees or to call a meeting or to direct the trustees to do something?
Not in this situation, Your Honor. The only thing that they might be able to do, which I tend to doubt, is to vote to amend, say, the master deed, which would require not only their action, but also the consent of all their mortgage holders. And so my argument is that as a matter of law, really, they should not, a condominium in this particular type of situation, and this is on the facts of this case, that they are not entitled to notice. Are there any other questions on this issue?
I think I understand your position.
Excuse me?
I said I understand your position.
Thank you. So then let me move on to, this was a decision by Judge Nickerson. This was part of his decision. Let me move on to the decision for a minute by Judge Ricciardoni dealing with the room itself, the expansion of the room into the common areas. I think that he made two mistakes. Number one, he based his decision upon Section 5A of the of General Laws, Chapter 183A, which was not amended into the statute until about 11 years after the certain of the limited common areas was switched and returned for expanding the unit. And the second thing is that he relied on Cavallo, which is a case where a unit owner who had 50% of the beneficial interest took some common area for herself and turned it into limited common area. In the case of McQuilly's predecessor, what he did was he already took what was already limited common area. He didn't take any extra land, but he he gave up part of his limited common area in return for the expansion at a time when the only law that was in effect was the case of Kaplan versus Boudreau, which required 100% of the unit owners to agree. And in the record, as you will see, there was in fact agreement by 100% of the unit owners. Section 5A was not around at that time. And
sorry, you said that 100% of the unit owners did agree to the expansion of his unit?
That is correct.
My understanding is that that there was never any amendment to the master deed or other formal determination that the expanded area was incorporated as a part of the unit, and that was one of the issues that was still in dispute before the Superior Court.
And that is absolutely correct. There was no amendment, but there was no amendment required by the statute or even by Kaplan versus Boudreau.
Well,
all it said was you needed a vote of 100% of the unit owners.
To incorporate or annex a portion of the common areas into a particular unit, it would also require a concomitant amendment to the master deed to redraw the boundaries, the square footage, and the percentage interest of of that unit.
Even if so, Your Honor, even if so, what McQuilly's predecessor gave up was a portion of the common areas and facilities of his limited common area. I'm sorry, he gave up a portion of his limited common area that he already had.
I understand what happened. Okay. The question is whether what happened conformed to the condominium statute.
Assuming for a minute that it didn't, Your Honor. I'm not conceding that, but assuming that it didn't, the second part of what Judge Ricciardoni did, which was add on a fee, an additional fee for the use of that area, which was already McQuilly's predecessor's right to use anyway. That part of it was wrong in any event. So assuming that the court is of a mind to keep this as a limited common area, okay, as Judge Ricciardoni determined, nonetheless, that additional charge should be removed because it was already figured into what McQuilly's predecessor purchased when he purchased the deck. All they did was expand out a little more onto the deck, and he gave up some of the deck. So there was an agreement that had been made between the parties that was fully carried out by both of them. And in fact, nobody ever complained about this taking of additional property, as it were, okay, until this lawsuit was started. All they were complaining about was the charges for it.
I take it the charges and also the distribution of rental income.
Well, the distribution of rental income is a whole other issue, Your Honor. The whole thing with rental income was, number one, and by the way, I believe it was Judge Nickerson who said that there was an implied contract with regard to the rental program. But the rental program is in violation of the condominium documents. The master deed in section 7 provides that the unit owners have the right to rent their units. Yet, as you will see from the deposition transcripts of both Mr. Flynn and Ms. Balfe, that they were not allowing people to do that, because that would have upset an entire.
Isn't it entirely possible for unit owners to delegate by agreement to a management company the full authority to rent their units on their behalf? That's my understanding of the implied contract that Judge Nickerson recognized.
Clearly, one can contract, one can rent the unit, one can lease their unit to someone else, and I suppose one can give someone the right to rent their unit for them. But in this particular case, the parties who were involved, Mr. Flynn, an attorney, Ms. Belfi, a CPA, they were insisting that people rent their unit through the rental program and refused to allow them to rent them on their own. And nonetheless, in spite of this, the people in authority denying others a certain right, nonetheless, Judge Ricciardoni said, this is an agreement.
Judge Nickerson.
I'm sorry, Judge Nickerson, right. I'm sorry, thank you. So therefore, I think that there was error in that as well.
Just out of curiosity, Mr. Goodman, you were trial counsel, right?
Yes.
There are several elements of this case that that make me curious why it was brought in the Dukes County Superior Court instead of in the land court.
It was actually, that was inconvenient for me because I'm not located out on the vineyard. Nonetheless, because there were several issues that I thought there were issues involved in this case that had nothing to do with title. I felt that the Superior Court was the more appropriate place to bring this.
Was that a question of jurisdiction or a question of the nature of the claims?
I think it was a question of jurisdiction in part, because I don't think that the land court had jurisdiction over all of the claims that were involved in this case.
Okay.
Including a request for an accountant.
I have a question, switch gears for a minute. Counsel, with respect to your ultra various claim, I'm not clear on what you're actually arguing there. Can you summarize for me what it is that you're focused on with that point?
I'm sorry, the ultra virus claim with regard to the rental, it was basically that the board had no right to insist that, and to dictate to unit owners that they have to go through the rental program and cannot rent it on their own. In violation of Section 7.
I'm not sure that this is whether this is related or not, but it's not clear to me from the briefing and from the agreed statement of facts whether your clients are contending that the trustees have been to trustees during the relevant period or not.
One of our contentions would be that the current trustees really are have acted long beyond when they were elected, and because of the way that they called for meetings, at the times that they called for meetings, and how meetings were held so that there was never a quorum for decades, that they really, they shouldn't have been acting as trustees.
And you're saying, I take it that the unit owners collectively nonetheless have no right to impose demand on the trustees that they hold a meeting, or that they stand for re-election, or that they do any of those things.
Fact is that the trustees have called for meetings where there was never a quorum because they called for them in November.
No, I understand that, but what I think, going back to our conversation on the derivative issue, you're suggesting that it was that the unit owners were powerless to protest that pattern of conduct.
I think that the unit owners did have the right to demand a meeting, that they would have had to demand that a meeting be held at a different time of year.
I would think so too.
Because meetings were held. Yes. Yes, I do not deny that.
All right, I see that your time is coming to an end. Is there anything else you'd like to tell us?
Your Honor, I will rely heavily on my brief because there's more to discuss, but the whole issue of the accounting and so forth, but I'll rely on the brief for that.
Thank you. Mr. Goldsmith.
Yes, good afternoon, Mr. Chief Justice, Justice Shin, and Justice Hand. I'm Michael Goldsmith, appearing for the appellees, the Vineyard, Harbor, condominium trustees and the Vineyard Harbor Condominium Trust. Let me just first address what Mr. Goodman's second issue, the Judge Riccardoni decision. And I'm a little surprised that he focused heavily on that in the argument, because in reviewing his brief, I saw only one or two short paragraphs about that. And I'm not sure the argument rises that was presented to the level of an appellate challenge. But in any event, Judge Nickerson scolded us both, really, in his decision, because part of the complaint, count 2, brought on behalf of Kevin McQuilly, asked for a declaration as to the lawful status of the expanded unit that had gone from 422 square feet to 663 in 1989. And he said, both of you have not argued sufficiently to me to resolve that issue. So after the summary judgment, cross motions for summary judgment came down, we had this remaining portion of count 2, and we lined it up. We briefed the issue for Judge Riccardoni, and he commenced it really as a trial on agreed facts under Rule Superior Court 12B, which I've set out in my brief as a sort of a more lenient standard for his decision. But the issue of how to treat the expanded Unit 42 had plagued this association for years. And the trustees had, in sort of in a ham-handed way in 2000, tried to make an adjustment to the beneficial interests. But not to blend over to the derivative argument, they self-corrected on this, because in January of 2014, the record shows, the trustees, as these complaints were getting underway, decided to return the beneficial interest back to what was recorded.
But they're not operating on a blank slate here, right? This condominium statute has some fairly strict rules and requirements about how these things are done.
Yes, it does, Your Honor.
The actions of the trustees, at least as framed in the arguments in your respective briefs, and I mean, I can understand, to use your term, in a rough and ready way, what Judge Riccardoni was trying to do. But I have a hard time, and I've done some work in this area, I have a hard time trying to find much relationship between those statutory rules and the disposition either by the trustees or by Judge Riccardoni.
Well, Your Honor, by the time the matter got back before Judge Riccardoni, the trustees had used for many years, since January 1st, 2014, the recorded beneficial interests to apportion expenses, either both on the rental program and the condominium statute.
But the beneficial interests by statute are based on the relative fair value at the time the master deed is recorded. There's a lot of discussion everywhere about the difference in square footage, but square footage is not the determining factor. Sometimes square footage can be something of a surrogate in certain markets, but particularly in waterfront locations, there are differences between units, including view, that bear on the relative value of one unit to another.
I think that's true. If you look at the master deed and the trust documents, though, the tables listing out do list the square footage in very near and in connection with the beneficial interest. But we're not here because it's not a derivative case about everybody else's unit. We do know that the trustees have returned to charging everybody what's in the recorded documents. And the only question was, how do we deal with the expanded Unit 42? And Section 6A22 says that the trustees may, when they're assigning a limited common area, assess the cost of maintaining that area to the unit owner who benefits. And we presented these arguments to Judge Riccardoni that in 1989, when the roof, Unit 42 is the only unit on the third floor in the second building. And the deck that unit owner had was a large flat roof that we all know was probably not a good thing in New England. And when that went south and started leaking, and they reconstructed that roof and converted it into a pitched roof, Unit 42 was expanded by the 221 square feet. And as Judge Riccardoni said, he swelled to that size, and it far exceeded the size of any other unit. The owner at the time, Mr. Tellup, was the president of the association, consented to the change.
Let me just ask you for a moment, though. What was,
yes, sir.
It's important. What was the status of that expanded area? Was it a part of the unit, or was it a part of the limited common areas? At that moment in time, when everybody consented, what was it? When you give me that answer, I'd like you to follow that up with an explanation grounded in the statute of why that complied with the statute and the cases at the time.
The expanded area was a limited common area for the exclusive use of the owner of Unit 42.
And what was it under the statute in the cases at the time that authorized the enclosure of limited common areas within the coextensive interior space of a condominium unit?
Well, I don't think I can find those words exactly in the statute, Your Honor, but Judge Riccardoni relied on section 5B22 that when the case was brought for, excuse me, Your Honor?
It was not in effect at the time, right?
That's what Mr. Goodman has said today.
Well,
yes.
it's certainly true.
But we had the case the case wasn't brought till 2014, and the issue had to be resolved. So I think Judge Riccardoni appropriately applied the existing statutory framework to deal with this question.
Can you tell me how if the let's pretend that the statute was in effect in 1989 when the expansion was done. How does the statute authorize the enclosure of limited common areas within the coextensive interior space of a unit based on the consent of the owner of that unit and the trustees?
Well, because the very nature of a limited common area, it is for the exclusive use of the owner and nobody else. And no other adjoining unit, this is another statutory factor, no other adjoining unit owner is impeded from access to their unit by the enclosure. There has been consent. The trustees set terms and conditions, which is the statutory term in which they did. This is now your area. I mean, this is Judge Riccardoni's decision in retrospect, and you need to pay an additional maintenance fee to have that area. I mean, it is a bit of rough justice. There's no question about it, but this was a long simmering issue in the association, how this expanded larger unit was to be treated fairly. And it was expanded by 63%, and the 1.97% additional common area fee is essentially the same. It's a 64% increase. So I think it does meet the present day statutory text of section 5B22, provided there is some follow-up if the judgment is confirmed, seeking consent from the mortgagees and recording a plan and so forth, which hasn't been done. Obviously, with this appeal, the trustees are proceeding on the path that they've been using, and are not charging Unit 42 this additional amount as of yet. Just briefly, Your Honors, on Mr. Goodman's argument about the derivative case. I mean, I think Judge.
Before you move on, Counsel, I did have
yes, Justice.
I have not done much work in this area, so maybe you can explain it to me in simple terms. What authority did Judge Riccardoni have to authorize the added assessment? Where does that authority come from?
As I said in response to the Chief Justice's question, in my view, under the present existing statutory text, there's section 183A 5B22, and then 183 section 6A little 2 or double I.
And
Those
what language are you relying on?
In section 6A 2, I'm relying on, notwithstanding the provisions of the above paragraph, the organization of unit owners, which is the trustees, may assess the cost of maintaining, repairing, or replacing a limited common area and facility solely to the owner of the unit to which a common area and facility is appurtenant, allocated, or designated. And such assessment shall be enforceable as a common expense assessment under this chapter. And then
But
5.
But Mr. Goldsmith, on that,
Yes, Your Honor.
Those are expenses incurred by the association in maintaining those limited common areas. It's unclear to me how that can even occur when the area in question is enclosed and made, for all practical purposes, a part of the unit itself.
Well, number one,
activities of maintenance that give rise to the related expenses that 6A2 authorizes be assessed against that unit owner.
well, for example, there's insurance, Your Honor, and I assume the association pays insurance. It's understood that all the unit owners rent their units out, and you know, if there were some incident there could possibly be a claim against the association and against its insurance, and the
insurance is again based on the relative percentage beneficial interest that each of them has pursuant to the master deed, and if that's not an expense that ties specifically to the limited common areas. So the language that you're alluding to in 6A2 speaks to the cost of maintaining limited common areas themselves.
Well, maintaining, I think insurance, as an example, is maintaining. The association does have workers that go in and do cleaning and all that sort of thing, which is connected to the rental program.
I thought that was outside of their role as trustees and in their role as contractual managers under Judge Nickerson's framing it as an implied contract in fact.
Yes, that is true, Your Honor. So I think I've done my best to answer your question, Justice Shin, of the provisions of the statutory framework that we say gave Judge Riccadoni the authority.
This was always a limited common area for the exclusive use of Unit 42, right?
Yeah, yes, the portion that was enclosed was part of the flat roof deck.
Right.
That
so
was always.
It was always.
Yes, it was. Yes, it was. It's shown even on the original condominium documents. There's a map that of this. You know, there's plans of the entire complex, and there's a plan of this floor.
In fact, the modification that gave rise to the enclosure of that limited common area reduced rather than increased the total quantity of limited common area that was applied for the exclusive benefit of Unit 42, right?
That is correct. As Judge Riccadoni said, though, it may be a little too much to make much of that, because basically it was a big flat rubber, rubber roofed area where there were actually stairs leading up to. It was that you could get to. And now when it's enclosed part of Unit 42, there is no access to it. And and this was all paid for by all the owners, by the association. The roof had to be done, and the Unit 42 owner also got a replacement deck on the back of the unit that looks over the water. So there's some other factors involved. But like I said, this was the plaintiffs brought this case and sought to have this issue resolved, and they didn't claim anywhere or make the argument that McQuilly now owns it, or the owners own it in fee. And
I sort of, maybe I was reading too much, but I thought that was the gist of their request for a declaration of its status.
Well, I don't think they advanced that argument anywhere. They just said to have it declared lawful as it is, just and without any statutory underpinning. So I see my time is running out, Your Honor, and I'll rely on my brief for the balance of our arguments. Thank you so much.
Thank you both. Case